and subsequent executive orders extending the state disaster emergency declared in Executive Order 11. Further, the public does not have the ability to view and listen to this proceeding in the manner consistent with authorized authority. In addition, the meeting will be recorded and later transcribed. So with that, we'll move along with the agenda. The first item is approval of the 4/19 and 5/18 meeting summaries. I need a motion to approve as written.
I'm happy to approve.
Okay, a second?
I'll second.
Does anyone have any amendments to those minutes? Seeing no amendments, the meeting summaries are approved. We'll move into section 2, the department and subcommittee reports and the enforcement report, please.
Hi, it's John Goldman with licensing enforcement. So I'll just get statistics out of the way first. We ran statistics for the second quarter of the year, April through yesterday, close to the full second quarter of the year. In that time period, the department received and opened or otherwise initiated on its own 90 new cases, 9-0. In that same time period, we completed 155 investigations. Of that number, 29 were referred for hearing, which is right about 19%. We find that about a fifth of all our cases following investigation warrant disciplinary review and are referred to our legal folks. So that's right on line. 29 out of 155 is roughly about 19%. See, the balance of 126 were closed under a number of different categories. And following past reports, I'll kind of list those for you. Of the 126, 25 were closed for, after evaluation, insufficient evidence to warrant further action. 21 were otherwise settled or resolved without any further action. 17 were abandoned or withdrawn. 15 were concluded to not have any violations worthy of further action or no merit. 15 were resolved with some sort of instruction or warning to the licensee in terms of something they did or did not do, not being in line with statute or regulation. 12 were deemed to be civil. 8 were closed with a hold. And again, hold is a disposition we utilize when the licensee's license has expired or is shortly therefore going to expire, and the issue is minor, typically involving our inability to communicate effectively with the licensee, so we put a hold on their ability to renew. 2 were deemed to be no jurisdiction, another 2 were duplicates of another, and 9 were otherwise closed. I was also asked to mention to you 2 new enforcement initiatives that the state has begun in the second half of the year, pretty much beginning on around the June 1. One is what we're calling an Internet Enforcement Unit, where we have enforcement personnel who are detecting marketing websites, specifically with a focus on the fair housing statement, the necessity for that to be posted on the website, and of course the new addition of the standard operating procedures, and we're detecting sites that are not in compliance with that. We also, in addition to those 2 fair housing pieces, are looking at what would amount to be violations of the advertising regulations. It's a focus on the necessity to use license types. In marketing material, the license type of a license holder is required to be identified. We also have a large problem with aliases, where folks just take on names that are other than their license names. So we look for that as well. And so that unit is identifying those issues and, depending upon the severity of them, communicating the concerns to the brokers of record, and in some instances, there's disciplinary action pursued. The other enforcement initiative revolves around it's not new, it's a couple years on the books now, the necessity for schools to record fair housing, the delivery of fair housing instruction. We have, in essence, conducted audits relevant to that requirement, and with mixed results. And I believe administration is going to continue both of these initiatives, especially since they're brand new. But we have found some, some concerns regarding failure to comply that warrant, the process to continue, the audits to continue, to hopefully get the word out of the necessity of the recording aspect as it relates to the schools. The state does put effort into communicating these requirements and necessities as the legislation is passed or the regulation is enacted. We send out mass emails. So we feel we're adequately communicating these changes and new legal requirements. And so this is just coming full circle, ensuring that compliance is at an acceptable level. That's the extent of my report.
All right, thank you. Are there any questions from the board members? All right, thank you. Moving on to the processing report, please.
Good afternoon. Included in the materials you were provided is a report of the number of current real estate licensees for May of 2021 and May of 2022. The report groups licensees into broker and branch office licenses and salesperson licenses. The totals are listed by county. Please note that the 2021 numbers include only licensees and do not include those licensees whose licenses may have expired but were covered by Executive Order 202.11, which had allowed individuals licensed by the department to extend the expiration of their license during the state of emergency. And that concludes the processing report.
Thank you. Are there any questions? All right, the education report, please.
Good afternoon, everybody. Recent legislation has amended the qualifying education for both salespersons and brokers. Effective September 21st, 2022, real estate broker applicants must complete training in cultural competency in order to become licensed. Effective December 21st, 2022, the salesperson qualifying course will increase from 75 hours to 77 hours. Also effective December 21st, 2022, the broker course will increase from 45 to 75 hours and requires instruction pertaining to the following specific topics: legacy of segregation, unequal treatment and historic lack of access to opportunity in housing, unequal access to amenities and resources on the basis of race, disability, and other protected characteristics, federal, state, and local fair housing laws, and anti-bias training. David Mossberg will be presenting more specific information about the above changes, but are there any questions right now? Thank you.
And lastly, the examination report.
Good afternoon. From January to May 2022, the real estate salesperson examination was administered to 11,921 individuals with an overall pass rate of 51%. In that same time frame, the real estate broker exam was administered to 1,039 individuals with a pass rate of 54%. As previously mentioned, the exam capacities at our exam sites will be increased back to 100% starting July 1st, 2022. Currently, the average wait time statewide for an exam appointment is approximately 1 week. Any questions?
Those pass rates seem unusually low. Is that about right for the pass rates?
That's pretty consistent with what they were at the compared to our last report.
Good, thank you. All right, moving on to new business. Dave Mossberg, the executive order update, please.
Good afternoon, everyone. So just a quick update. EO 11.7 was issued by Governor Hochul on June 14th. That EO extended the opportunity for public bodies such as this board entirely virtual. If you recall at the last board meeting, they vote to adopt formal procedures to allow for partial remote meetings wherein there's extraordinary circumstance. At the last meeting, I advised that unless the EO again, we'll have to in person. However, the EO was extended through July 14th. So we'll have to wait and see what happens after the state, see if it gets extended again for our board. So that's the update on the executive orders. Don't know if anyone has any questions or concerns.
Okay. Moving on to the next item, discussion on regulatory changes relating to fair housing legislation. It's you again, David.
So as Allison had started to discuss or mention previously, and I'm sure the board knows based on prior board meetings, the end of 2021, early part of 2022, there were various bills that were signed, including several chapter amendments relating to real estate salespeople. Relevant to the discussion now are those changes that relate to the educational requirement really going into effect December 2022. As Alice mentioned, the person's course is increasing to 2 hours. The broker course is now being increased as well. Part of the statutes or the bills that were signed into law required the department to develop the curriculum that would be required to satisfy these new educational requirements. The law also required, for example, other changes to include that schools affirm basically that they are instructing consistent with the statute, and that specifically requires the department to pass regulations for disciplinary action to be commenced against providers if it's found that they fail to meet those requirements. First penalty, for example, is suspension of a license, and then thereafter, repeated offenses. The statute dictates that the instructor approval be revoked. So in addressing or trying to work out what the new statute requires, or probably is aware, there was an ad hoc advisory committee that consisted of Alice and Lacey, Marcia Rose, Jody DeLallo, Neil, Duncan, and others. And so, you know, I first want to thank all the board members, ad hoc members for assisting and helping develop the proposal, which is before everybody. And so I'll just go over that sort of and then answer questions for the board. So the current proposal seeks to amend sections, and I apologize for running through section 176.3, 76.4, 76.15, 76.16, 76.20, 76.25, 77.1, 77.14, repeal of 176.26, paragraph B of 176.8, addition of new 176.26, a new paragraph B to 177.8, and new paragraph B of 177.18. The draft regulation specify sort of what those changes are. But in general, what we did was any place in the current regulation where it said, you know, the prior 75-hour coursework for sales, we changed that to 77. Anywhere in the statute, sorry, anywhere in the regulations where it previously referred to the 45-hour broker course, we updated it to reflect the 75. So that's why there's a lot of changes. A lot of it is just sort of to conform with what the requirements are. Same with, for example, the requirement under the statute that we, for example, require the schools to submit these affirmations. They be submitted electronically to the department. That's the statute. The additional changes that we had made, though not expressly required, but we believe are required to ensure that, for example, took prior courses wouldn't have to do the whole new courses over again. So what we did was we added new supplemental courses. I'm sure the board may know that previously, if you had taken the old broker course, you would just take the supplemental 30-hour course. So we're keeping that, but then we recognize that we need to create like a 32-hour supplemental course, other sort of situations depending on what the student had, so that they would now be able to meet the minimum requirements. So that's included in the proposal. Also included in the proposal are some cleanup items. So for example, back, I believe 2 years ago, there was a change that was a grandfather exemption for brokers that had been previously licensed 15 years prior. All brokers, salespeople are now required to take any medication. There's no longer. So we're cleaning up the regulations where it sort of referenced the prior exemption. It's no longer applicable, deleting it. But the real sort of substance of the course or the proposal are the changes to 176.4. That is the regulation that increased 45 hours to 75 hours. So we work closely with the committee. I'd like to thank again, everyone who worked on it, in particular Bill and Duncan, for helping provide comments on what those new additional hours of education are going to focus on. So that's reflected in, as I said, the 176.4 change. Also, because we needed to also create a 32-hour supplemental course, we basically mimicked that as well. The new course is a 32-hour supplemental course. So again, these changes are necessitated by the new fair housing that was law. And in order for them to go into effect, what we are recommending to the board is that they vote to approve the proposal to authorize the Department of State to file any all necessary papers to file this proposed in the state register, as well as any and all measures necessary to adopt, at the end of the comment period, provided there are no substantive changes, can go into effect. Something that I just want to mention is the time of the rule. Assuming the board votes, as I just sort of described, we anticipate that we hope to file this for publication in the register by next Tuesday. If we do hit the deadline, this will be formally published in the state register as proposed on July 20th. The statutes that are necessitating rulemaking, unlike school board rules, requires a public hearing. So under the State Administrative Procedure Act, public hearing can't be held less than 60 days from the date of publication of the state register. So if this is published in the state register July 20th, the earliest a public hearing could be held would be September 8th. So looking at the calendar, we're proposing a public hearing. The board doesn't have to attend, but it will be open to the public. The public hearing will be scheduled for September 21st. The public comment period under staff has to be 5 days after that. So it'll run through at least September 6th. If there are no public comments or nothing substantive, depending on the board vote, we'll be able to go ahead and file adoption and make all this permanent. If there's something substantive, we'll have to bring it back to the board, depending on how the board votes now, to then make any necessary changes and file the notice of adoption. If we're able to file the notice of adoption early October, it will be in effect, obviously, before the to allow schools, students, and the become licensed sufficient time for that is sort of the timeline, the nature of the rulemaking. I guess it's open for discussion. So, if there are any questions or concerns?
So why don't we just do we have a motion to approve the documentation that was sent to you on the new regulations?
We could do that.
And then we can just open up for discussion.
Yeah, I'm not sure if any of the board has any questions prior to that.
How about a motion and a second, then we'll open it up to discussion if there is any.
Second.
All right, so is there any discussion about the proposed changes? All right, not hearing any. All those in favor, please say aye.
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 Anyone opposed? Any abstentions? All right, the proposal passes.
Tricia O'Connor's here. I just wanted to point out that Tricia O'Connor's here. Sorry.
Thank you. Thank you, Dave. And you and your staff, everybody there at the US really did a great job. It was a good process getting to this point, so thank you. The next item is the next meeting date.
The next meeting date is set for Thursday, July 21st at 1 p.m.
Denise, can I add something here?
Sure.
While we're talking about this, Dave, I don't know how the board members feel. I think the July date was only on the schedule prior to us scheduling this meeting. So if we don't feel it's necessary to have the July 21st date, I think it's a good idea to cancel it and just be ready for the meeting that's necessary to approve the regulations. Dave, do you see any reason the board would need to meet by July 21st? Should we keep that meeting? Do you think it wouldn't be necessary?
I can't think of the reason why. Based on board vote, take necessary measures, file the notice of proposed rulemaking, and if necessary, move forward with the notice of adoption, provided that there's rule changes. I don't have. I'm unaware of any particular need for the July 21st.
Okay, so if you're all in agreement to that, I'm okay with postponing that meeting or canceling that meeting.
Yeah, we can cancel that.
Yeah,
I agree. Cancel it.
Will do.
All right, there being other agenda items, this meeting is adjourned, and now we can move into the public hearing session.
Thank you, Duncan. So, to RPL 442I, paragraph 6, in addition to the regularly scheduled meetings of the board, the department and the board is required to hold a public hearing in New York City, Buffalo, or in Albany. The purpose of these hearings shall be to solicit from members of the public suggestions, comments, and observations about real estate practice in New York. I'm not sure if there's anyone from the public that would like to participate or make a comment. If there is, indicate.
I'm going to mute a couple numbers that are not identified. I have muted a couple numbers that were not identified in case that's anyone from the public that wants to make a comment. Okay.
All right, thank you, Denise. There being no participation from the public, now stands the opportunity to do so. The public hearing portion of the meeting is going to RPF 4 closed. Thank you, everybody.
Thank you.
Okay.
Thank you.
Good summer.
Have a nice summer,
Thanks.
everyone.
Everybody.
Thank you.